1.5 kilometres southeast of Largs, Camehill, Fairley, North Ayrshire, also referred to as the Crosbie wind farm. I've been appointed by Scottish ministers to hold the inquiry and thereafter report to them with a recommendation on what should happen to the proposed development. The purpose of this pre-examination meeting is to discuss how the inquiry can be conducted in the most efficient manner. Now, there are a few housekeeping matters before we proceed. Please note that today's meeting is being filmed for live and subsequent broadcast via the DPA's website. By participating, you're consenting to being filmed and the use and storage of the images and sound recordings and any information pertaining to you contained in them for webcasting and training purposes, and for the purposes of keeping historical records and making those records available to the public. Any information presented by you, in addition to forming a record that will be held as a historical record, will also be held and used by the DPA for the relevant matter until that matter is decided or otherwise resolved, including any potential appeals and other connected processes. Continue, but at the minute it's absolutely fine. Okay. Now, if anybody has an issue with hearing, if you can't hear me at any point, okay. Now, if anybody has an issue with hearing, if you can't hear me at any point, please tell me. The system will tell you like subtitles what's being spoken. Okay. And this is being recorded, so you can view it back. And there will be notes of this meeting, which I'll come to later that you can read.
Guidance was I don't think there has been a change. I just think it was maybe the way it was.
Any problems, Mr. Thompson? Just interrupt.
I think
help you out. That was item 1 in the agenda. We're going to move on to item 11. Now, I'll have the Prince Parsing with the applicant. Including any potential.
I just want you to give an name.
My name is Marcus Trump. King's Town structured by Craig Weston of Sheffield Weatherburn, who is on this call. I'm accompanied on the call by Claire Dowse, who sits in the office of the Chief of People. She's head of operations UK for the applicant. With her is Laura Pitry, Senior Project Manager for the applicant.
So
we have one more online, but I won't name
Craig, do you mind just taking the notes for this one? And in that email, you could just delete the stuff that's all been done and just keep the stuff on it that's still getting carried on.
Is Colin Laverty with you?
I see
yes,
David's
sorry,
missing. You're right, David.
That's someone I was missing. Colin Laverty, Planning Director of Stand Safe to Account Consultants for the applicant.
Don't worry, don't want you get pulled all directions and stuff.
He's
watching the webcast on his feature. He's watching the webcast.
Now, I will interrupt every so often, or you'll hear me typing away, perhaps.
David,
that's just so I can keep the
look
notes of the meeting. Now to North Ayrshire Council, if you can introduce yourself, thank you.
To do that or not?
Got an email back from
Seth
Morgan, so we'll upload them to YouTube. I'm just getting them done as soon as I can, and I'll get the links added to K-Hub. I think I'll double check with them because I'd suggested putting the ASTI one as private, so it's the most secure.
Thank you very much. Now,
so I'll double check that's what he wants.
And
suggested that,
groups
but
on
the
the
answer
call
back was
today.
so for both of
what I'm going to do, I'm going to call out names.
So I'll get that to check,
and then we're
to
going
make sure I don't put it on the way he doesn't want it.
That haven't had their name called out. So firstly, is there a representative here from Glasgow Airport?
Seems like they're both good to go up.
Yes, good morning, sir. My name is Stephen Blaine. I'm a Senior Associate in the Litigation Team at St Masons, based in Edinburgh, and I'm also joined on the call by Kirsty McDonald, who is the Airport Safeguarding Manager.
And what K-Hub is, and we'll get him added. Every time I hear something, I go, we need to add Craig to that. So we need to get Craig.
Super, thank you. And from Nat Safeguarding?
Yes, good morning. Alistair Auld. I'm here representing Nat Safeguarding.
Thank you. Are you correct spelling of Alistair, I see?
Yes, indeed. Yes, the only way to do it.
Thank you. Okay, and then from Fairley Community Council?
Hello, I'm Rita Holmes. I'm Chair of Fairley Community Council.
Hi, pleasure to meet you. Thank you. West Kilbride Community Council, that's yourself, Mr. Thompson?
That's correct.
Okay, and you're representing both the Community Council and yourself, is that correct?
That is correct, because I have different matters in consider with the Community Council.
Brilliant. Okay. And then we have Obo Fairley Community Council. Is that Mr. Grosvenor?
Yes, sorry, I was just finding the link to switch my mic on. Yes, I'm here, sir.
Is it just yourself from the Community Council?
No, I think...
No.
Okay, sorry, if you could just confirm.
Jackie Pearson is also here.
Okay, brilliant, thank you. Excellent, thank you. And then we have CWP Energy.
Hi, good morning, sir. It's Rob Fryer from CWP Energy.
Brilliant, thank you. Thanks. And then Friends of Clyde Muirshiel Regional Park. Anybody hear from them? Oh,
yes. Yes, I'm Parsons. Myself and Joe Greenlees are representing Friends of Clyde Muirshiel Regional Park.
Brilliant, thank you. Mr. Duckett.
Yes, I'm here.
Brilliant, thank you. Eric Gold.
Yes, I'm here.
Brilliant. And just to confirm, yourself, Ms. Gold, and Mr. Duckett, you're both individual local residents. Is that correct?
That's correct.
Yes.
Yeah, brilliant. Now, Miss Les Parents. Apologies if I've mispronounced that. Yes, sorry. Mr. Yes. You're a local resident as well? Yeah, I can't hear you. You're on mute. Okay, brilliant. Miss Pearson, we've heard from you. Mr. Riddle?
Sorry, the Jackie Pearson that you had was Rita Holmes was pointing out that I'm also on Fairley Community Council, but I'm here as a representative just of myself as a resident of Fairley. Thank you.
No problem. Okay, Mr. Riddle, you're there. I can see you.
Yes, good morning, sir. I'm present.
Brilliant. And we've heard from Mr. Thompson. Now, is there anybody else on the call who I haven't heard from or hasn't introduced themselves? Yes, Miss Cameron?
Yes, good morning. My name's Lisa Cameron, and I am head of planning at Glasgow Airport. I'm just observing today.
Okay. Brilliant. Thank you. Now, I'll just get you to put your hand down, Miss Cameron. Thanks. Just to note that Alistair Adamson, has opted out, but he wishes his written representations to be taken into consideration, which I will in my report to Scottish Ministers. Glasgow Prestwick Airport have also confirmed that they won't be attending today, but they're content to have further written submissions on airport/flight interests. But we can come to that under the correct agenda item. So we'll move on now to the Code of Practice. Thank you all for introducing yourselves. There are no statutory rules relating to Electricity Act cases. Therefore, I intend to deal with the inquiry in accordance with the Code of Practice for Electricity Act cases, which is available from the DPA website and was circulated as a hyperlink within the agenda for this meeting. Using the code allows for flexible procedures. Each issue can be dealt with by the most appropriate mode of examination. This could be an inquiry session, a hearing session, or further written submissions. On some issues, sufficient information will already have been submitted and no further procedures will be required. Are we all agreed to using that code of practice for this inquiry?
Yes.
Yeah, any dissenters, just put up your hand. Mr. Thompson. I'm sorry, you're on mute, Mr. Thompson.
I haven't seen the code of practice because we only got notice of it on Monday when you sent out the notice of the meeting.
Okay. What I will do, there will be a copy of it within the note of this meeting. And for the purposes of today, I've put it in the chat, a link to it, so you can click on that and it will give you access to the code of practice as well. But essentially, it sets out basically the means of engagement on how we're all going to conduct ourselves throughout the inquiry, and it puts, I guess, the power in my hand to determine which processes we should use for each issue that's being raised, albeit that we're here today to discuss what the best means of processing would be. Okay, so if there's no further questions, we'll just move on to additional information. Mr. Trinick, could I just confirm whether there's any additional environmental information beyond that referred to in your updated position statement to be provided to the inquiry?
No, there is not, sir, including, I confirm there is no need for an update of the cumulative landscape and visual baseline.
Brilliant. So, I mean, obviously, as we have exchanges, further written exchanges, there will be environmental information within that, but it's part of the inquiry process. Any questions about additional information from anyone? Okay, we'll move on to item 5 in the agenda. Oh, yes. Who was that? Sorry.
We had a problem with flooding around the gasworks site, and we've been introduced to all the controls that seep up on water and water collection. And I would like to see during this process this confirmation that those regulations will be followed.
Okay, we have an issue on hydrology that we can bring that up in, Mr. Thompson.
Thank you.
Okay, moving on to item 5. Annex A of the PEM agenda sets out my initial views on topics requiring further procedure, and I've continued to consider these processes since the issue of the PEM agenda further. Just for everyone to note, when I write my report to Scottish Ministers, I'll take account of all the environmental information submitted by the applicant, together with all the consultation responses, letters of representation already lodged, and evidence arising from the inquiry process. The type of procedure being followed or the absence of any further procedure does not affect the importance of that particular issue. That's very important to understand. Now, before we go on and look at the list of issues, I want to briefly explain the differences between the procedures for those of you who haven't been involved in anything like this before or who are watching this online. Further written submissions involve a series of written questions from me for specific parties to respond to. Parties can then comment on one another's responses to these questions. In practice, it allows a full exchange by all the parties on an issue without the need to discuss matters. Hearing sessions take the form of a structured discussion between the parties involved, which I will lead. There is no formal leading of evidence or cross-examination. I would prepare an agenda for each of the hearing sessions in advance. Everyone who has advised me that they want to take part can participate in a particular hearing session. There's no need for legal representation, although parties' lawyers can take part in discussions. Hearings are generally more informal than inquiry sessions and are particularly suited for topics where there's a difference of opinion on less technical issues. For an inquiry session, each party would be invited to present evidence in turn, and this would be subject to cross-examination by those of an opposing view. Usually parties are legally represented and lawyers will question or cross-examine the witnesses, although it's not essential to have a lawyer. I will also have questions. Inquiry sessions are more formal than hearing sessions and are particularly suited to topics where there's a lot of technical evidence, such as where there's contradictory expert advice. Now, are there any questions from parties concerning those various processes? No, again,
Can I ask a question, please, Mr. Edwards? Yeah. It's Rita Holmes, Fairley Community Council. I note in the table that you sent out about whether things would be hearings, inquiries, or, written submission. I noted that for noise and vibration, I think it was merely written submission. And we would like to put forward a proposal that it's not merely written submission, if that's all right.
Sure. What we're going to do in a minute, we're going to go through each of those issues in turn, and we're going to discuss what the best process would be for each of those. So I know yourself and your representative, Mr. Grosvenor, will come in and discuss that you perhaps want an oral session on that, but we'll get to that in a minute, but noted.
Thank you.
No problem. Okay, so firstly, before we get into which process, are parties content with the issues that I've identified, essentially following the EIA structure? Okay, if nobody puts their hands up, I'll assume that that's agreed. Oh, yes, Mr. Duckett. You're on mute, Mr. Duckett. Sorry, you're still on mute.
Yeah,
that's perfect. Yeah.
I noticed that of the issues you outlined, there's one that's not there, which is fire risk.
Oh yeah, okay. Well, that will come under miscellaneous. We can certainly add that to miscellaneous and have a chat about it.
Yeah, I mean fire and explosion risk. If you don't mind me adding that.
Yeah, of course.
Oh, and just for the record, Mr. Edwards, my title is Doctor rather than Mr.
Oh, sure, Mr. Dr. Duckett, no problem. Thank you.
Thank you.
Right, now, two hands up. So, Mr. Thompson, you've started speaking, then I'll come to I'll get you to Mr. Thompson first.
Item 14, traffic and transport. Would it include the in-site communications, the roads that are going to be laid to service the various wind turbines?
Generally speaking, that's part of the landscape and visual impact assessment, but it can also come under things like peat loss, depending on where the roads are going, or tree loss, or habitat loss, or restoration. So it kind of depends on the issue that you might have, on where it might lie within these issues, if that makes sense, Mr. Thompson.
Well, my main concern is the construction of the roads. They talk only of small parts being floated construction, but the street is very wet, and even the existing forestry road, which is part of the original access, are all being reinforced with geofabric. And I'd like to see more detail on the road reinforcement and how they're dealing with water and drainage.
Okay, I've taken a note of that. Now, Mr. Lesperance, I've probably pronounced your name incorrectly, so you'll help me out here. But you have a comment.
Hello, can you hear me?
Yes, thank you.
Right, great. Well, unlike Mr. Duckett, my title is Mr. So, yes, thank you for listening. One issue that's not on the list that I would like to see addressed is the raison d'etre of this, the reason for doing it in the first place. Does it make any sense from a government point of view as a source of electricity? Because I don't believe that, and I think it needs to be addressed. In other words, is this cheap, reliable electricity?
Sure, I understand. There's a risk here that we get into evidence, and I understand why that might happen in a pre-examination meeting, but totally understand the point that you're making, and it's kind of cementing an idea that I've had. So we'll come to that in a second. So I think in consideration of these, I think there's merit in two further thoughts in terms of this list. The first one is a community hearing, something that we call a community hearing, which could encompass a lot of these issues that you're talking about in terms of the internal road structure and reinforcement of that, the fire risk potential from battery energy storage systems, and the issue about whether this is the correct correct means of generating electricity in this particular location. So we'll come back to that, but I think it might be a neat way to kind of encapsulate a lot of the community and individual concerns, and the Friends of the Regional Park. We can maybe all come together and have a community hearing session where it wouldn't be bespoke to one particular issue, but you could talk about all of the issues in general that you're concerned about. So we'll have a chat about that in a minute. The second thing that I think might have merit here is separating out the concerns of CWP energy into a bespoke issue that covers matters like effects on wind flow, efficiency, carbon balance for both the application proposal and downwind wind farms, micrositing and removal of or conditioning of some of the proposed turbines. The reason I'm thinking that is that the concerns from CWP Energy don't really seem to fall within any of these bespoke chapters in the EIA. I know that CWP Energy has said they want to be involved in LVIA, but it's not really an LVIA issue. It's a separate issue. So I think I'll ask parties firstly about their thoughts on, let's go to CWP Energy and we'll have a chat about having a bespoke issue just for them. And then we'll talk about a community hearing, and then we'll go through the rest of the issues and check if we're happy with those. So CWP Energy, any thoughts?
Well, thank you very much, sir, for that. That is a very good idea to have that as a separate element. Although we have highlighted some other concerns in terms of noise and the conditions and obviously the landscape as well, I think we would still like to be party to those. But if we're able to have a bespoke session that would look at the potential generation loss, wake flows and the like, whether other parties would be interested in that, then that's surely to themselves. But I would suspect that it was potentially just yourself, sir, Marcus Trinick, and obviously the applicant.
Okay, Mr. Trinick, do you have any thoughts about that particular process?
I'm happy to see a separate session for CWP in relation to wake effects, the issue which has been raised. But I think that if CWP has noise concerns, for example, they should be dealt with in a noise session and not separately. Otherwise, we have two noise sessions, which doesn't really make sense.
Yeah, so I could have just jump back in there. Yeah, that's really what I was saying, Marcus. I think in that term that we would still want to be party to the noise session, but then we could have a bespoke session which would talk about weight loss and generation.
Yep, sounds good.
Yeah, I mean, I'm interested in as well, as I say, the carbon balance. You know, you're talking about what that would mean for both the proposed wind farm and operational wind farms. Wind flow efficiency, what micrositing would mean for the wake, and how we might condition. So are parties happy if I encapsulate all of that, excluding noise? Mr. Trinick?
Well, as I've just said, sir, I think to separate out wake effects, the effect on the carbon balance resulting from that, whatever else flows directly from the wake effect issue, which is between CWP and the applicant, that makes sense. But in terms of other issues which are before the inquiry, I would not want, say, noise separated out as a separate session with CWP. Otherwise, we debate noise twice.
No, I completely agree. Yes. Now I have some hands up. Now I just want people to check that their hand is up because they want to speak and not because they've left it up. Mr. Thompson. You're on mute, Mr. Thompson. Now, Mr. Thompson, you're still on mute. There we go. Yep.
We had a problem with the existing wind farm at south of West Kilbride of the 15 turbines, 2 have run out due to the already exposed nature of the site. We put this in our comments. I think this would be something that would have to be examined, because at 200 metres, the height, there's going to be no drag over the soil, so it'll be ready with the high wind speeds on the wind turbines to blow this compass.
Okay, sorry, Mr. Thompson, what's your particular issue there? You talked about another wind farm, but what's the issue for this proposed wind farm?
I feel that it's going to be overexposed and therefore it has a higher risk of damage and burning.
Okay. Okay, no problem. That's something that maybe we could capture in a community hearing, which we're going to discuss in a second. Ms. Holmes?
Just a question really for Mr. Grosvenor, who's advising us on noise and things. I wouldn't like noise and vibration to lose out in any way if it's not discussed. I'm not sure of the consequences of your decision as to whether to just have it purely on everything other than noise. So can I ask Mr. Grosvenor for some advice, if it's forthcoming on that?
I welcome the idea of community wind power being involved in the noise session. Any other items that or concerns that Fairley Community Council have can either be dealt within the community session or within the other sessions themselves. That's what I would say. But noise obviously is a pivotal topic that we're concerned about, Fairley Community Council is concerned about. So that would encompass, as I said before, the cumulative impacts on noise involving with community. That's where I think we would sit as Fairley Community Council, if that's okay, Mrs. Holmes.
Thank you. Yeah.
Okay, thank you. So in terms, it sounds like a community hearing might be something that people would be interested in. We have a guidance note on that on our website, which I'll circulate as well. But effectively, it means that anyone participating can submit a statement of what their concerns are, called a hearing statement, and then they could come along and they could read out that statement and or an extract from it. And that could encompass these issues that you've discussed, like road construction, fire safety, the exposure of the site. And then the applicant could be there, answers through myself, and could ask a question myself of applicant. Is that something that would interest everybody here? Mm-hmm. Yes, Ms. Gould.
It is of interest, but I just wonder how what issues would be part of that and whether that limits our ability to discuss them all fully.
Well, what I suggest we do is we park it as a potential issue just now, and as we go through the list, we can quickly ascertain where people would like to discuss things, and then I'll get a feel for how many issues might pop into the community hearing session. With this kind of inquiry examination process, there's always going to be overlap between some issues, and that's just to be expected. The important thing is that I get the information that I require from everyone, and that you feel that you've all been able to give me that information to then convey that to the Scottish ministers, and then they can make the decision on whether to approve or refuse the application. So that's the key thing for the inquiry, is that we all feel that you've had a say, you've all been included, and you've all managed to convey your concerns and or support for the wind farm.
Okay, thank you.
No problem. So what I'm going to do now, I think we've got agreement that the issues set are correct. And now I'm going to go through each one in turn, and we're going to discuss how we're going to proceed with those. So if possible, I'd like you now to consider and confirm, if you're ready to, whether you intend to participate in any of the processes and who might be attending those processes or involved in them. I'll capture this information as part of the note of the meeting so everybody knows what's expected of them. I request that parties with aligned positions look for opportunities for joint representation. So, for example, community councils may want to nominate a lead community council for each issue, and they may seek to collaborate. Individuals may be also content to rely on evidence that will be presented by the council or community councils, or may wish to identify some lead community spokesperson to participate in the procedures. Now, I expect the applicant to be involved in all procedures, and I've given a provisional list of the parties I think would be best placed to share information on each topic in Annex A of the agenda. Now, we'll go through each of them in turn. So, the first one is the introduction, site description, etc. methodology. And I've said there I don't expect any further procedures other than there might be some discussion of methodology that comes about in the other issues. Is that agreed by everyone? Mm-hmm. Yes. Ms. Gold, I'll just get you to put your hand down, just so, thank you. Just brilliant. Okay, in terms of policy and legislation, I've said oh yeah, Mr. Thompson. Sorry, Mr. Thompson, you're on mute. You need to click the button off.
You're going to get some background noise, unfortunately, because it's an old plan house. What I'm going to be doing is my role as far as community council is concerned is to walk the site and see how the plans make out in practice on site, as opposed to just on the drawings. And I feel that some of the comments as to road construction, drainage, etc., which you said are going to be included, might well occur in that first section.
Oh, I see. In relation to the site layout.
Yes.
Yeah. Well, as I said from the earlier on, I totally expect that some of these issues will overlap, but in general terms, I don't think we need any further procedure in terms of those first 4 chapters of the EIA. Okay, we'll move on. In terms of policy and legislation, I've said a half-day hearing session. Mr. Trinick, are you comfortable with that?
Yes, with a process and a maximum of a half a day for that.
Okay. Now, I've indicated who I thought might be interested in taking part in that. So we have the applicant, North Ayrshire Council, and Community Wind Power. That's North Ayrshire Council first?
Yes, Mr. Edwards, yes, that's correct. My only observation would be that we would equally be happy to conduct policy and legislation by written submissions if that's streamlined considerations.
Okay, I'll come back to that. Community Wind Power?
Morning. Yeah, that's fine. To be honest, I think a hearing session half a day, as Marcus has suggested, would be ideal for that.
Okay, and I just want to focus down on, it's important for us all to understand why parties would be involved. So from CWP's point of view, is this to do with is it simply the carbon balance and policy 11 of MPF 4, or have you got wider policy issues that you're looking to raise?
Our understanding at the moment is MPF 4, the carbon balance, as you suggest, and also there's an element in terms of policy from North Ayrshire Council, but okay, we come across that bridge when we have to provide our information.
Yeah, sure. We'll come on to agreed statements and hearing statements in due course. Now, is there anyone else that want to be involved in a policy and legislation? Yes, Mr. Lesperance. I keep apologizing if I'm pronouncing this incorrectly. Maybe you can help me.
No problem, no problem. Thank you. I'm wondering does that include, when you're talking about carbon balance and that sort of thing, the overall logic of this kind of development, in the context of wind turbines, as contributing to any kind of carbon balance in terms of CO2 emissions, carbon-free society and all that? Is that what is meant?
Well, there's 2 things that you're raising there. One is to do with, I think you raised earlier as well, it's more to do with a strategic decision in terms of what type of energy formation is used. And then separately, there's something called a carbon balance, which is calculated for the particular development. So in this case, there's a carbon balance spreadsheet. It goes through various iterations of carbon losses and carbon gains, and then it comes out with a figure for how quickly this proposal would pay back its carbon balance and then would start being in the positive carbon, if that makes sense. So there are two bespoke things there. I think you're more concerned with strategic. Is this the right development, the right place? Is this the right process?
Well, even in terms of carbon balance, how wide is your scope of analysis? Because you can take the manufacturing of the turbines, for example, and where and how they are done, and start to enlarge the question, and legitimately so, in my belief.
Sure. So that could be covered under policy, and it could also be covered under climate change, but it could also be covered under a community hearing session. So I feel that I'm quite happy for you to come to the policy and legislation session because you're talking about strategic matters. But equally, I think a community hearing session would work for your points as well.
Wherever it gets, I don't mind where it gets covered, but I think it needs to be addressed.
Sure. Mr. Trinick.
So just trying to simplify this, all the issues which Mr. Lesperance raises will naturally come under the policy and legislation session. That's where they fall.
Yeah. Well, Mr. Lesperance, why don't we invite you to that hearing session? Would you like to be involved in that?
Sure. Sure. Thank you.
Okay, we're going to move on now. Climate change, Chapter 6, the EIA have said no further process. Oh, sorry, Dr. Duckett.
My application isn't raising my hand. I'm sorry. Well, at least it's not showing there. I wonder where you say there's a spreadsheet with the carbon balance. I haven't seen it. Is there a way in which I could see that?
I haven't sought that out as yet, but it should be in the technical appendices of the EIA, which will be on our website. So I'm sure if you have any difficulty in finding it, you can ask the applicant's team and they'll be able to help you.
Okay, thank you.
Okay, Ms. Holmes?
Just for my own clarity, under policy and legislation, I take it that regulations and guidelines, would they come under policy and legislation, or are they completely separate?
Well, they could, but if you're talking about specific regulations for something like noise, then that would come under a noise written submissions or hearing session.
Okay, thank you.
Okay, no problem. Okay, so everybody's content, no further procedure in climate change. Noise and vibration. Now, I have down here written submissions on issues like infrasound and human health. I'm going to come to yourself, Ms. Holmes and Mr. Grosvenor first. I think you're proposing a hearing session, so.
So may I just come in first here with a suggestion? Yes, a number of recent inquiries where there have been issues where some people want to see written representations, some people want oral process. A very efficient way of dealing with it is to seek written representations called further written submissions in the first instance, so as to inform you on whether or not further oral process would be required in order to adequately inform you of the issues so as to be able to report. And I suggest that for each of the topics which are listed for written submissions, but on which some people want to see oral process, that is the best way to go, rather than try and decide today whether to have oral process to receive further written submissions within a fine time scale, and following that you can decide what further process, if any, is required. So for noise and for the others, that will be my position.
Understood, yeah, and I've used that in the past. I think particularly with noise, because you know the presentations raise concerns with noise and infrasound vibration, but don't go into technical detail in terms of what exactly is of concern. So I need to understand that in any event. Ms. Holmes?
I disagree. I think we should have an oral session, and I think we have submitted in the past for different things, written submissions from people who've been affected, etc. So I would like to see it decided today that either we have an oral session on this, or we have an inquiry session on it. So I'm just disagreeing really with what Casey said.
Duckett? Sorry, you're on mute.
Yeah, sorry, the noise issue isn't just about, I mean, is the noise issue going to take concern the entire, because the noise from the Bess will be significant.
Well, any noise session could include discussion on any noise emitting from the Bess.
Okay.
So if you'd like to be involved in that, then that's fine.
It's not my field, I'm afraid. But
yeah. But you're raising whether or not any noise source would be considered.
Yeah.
Yeah. Well, yes. I'm going to go Mr. Grosvenor, and then I'm going to come to Mr. Fryer, and then I'm going to just have a quick look at the position statement from Fairley Community Council. We're just going to help, that should hopefully help us come to an understanding. Okay. Mr. Fryer, we'll go with you first.
Morning. Our preference would be a hearing session straight away. But also, I note that we're not actually noted in the parties list on the right-hand side of the Annex A. I'm not sure whether that's just been omitted as an error, but we would wish to be party of the noise.
Okay. Mr. Grosvenor?
Yeah, I echo the position of Mrs. Holmes and also Mr. Fryer. I don't see any merit in dealing with this just by written representations. Obviously, we can submit further precognitions that would act as written representations in part, but we have got a number of witnesses that wish to speak, and therefore, at the very least, we would request a hearing session, possibly an inquiry session, but that's for you, sir, to decide. But at a minimum, it should be a hearing session.
Okay, let me get a handle firstly, Mr. Grosvenor, on your witnesses. Could you explain which witnesses you're thinking about bringing along?
Certainly, there are local residents that wish to speak that have been directly affected by wind turbine noise, and we also wish to call Professor Mariana Alves Pereiras as well. We may have an acoustician, but at this time that isn't confirmed.
Okay. Mr. Trinick, and then I'm going to go to yourself, Ms. Pearson.
So the reason I suggest written representations in the first instance is so that you can be informed and we can be informed of the case which we may have to make, whether or not you need oral evidence. At the moment, we do not know the precise nature of the case. I'm sure others will say we do. We don't know the nature of the acoustic case that people want to put against us. If we get that clear in written representations, it may or may not be desirable to have an oral session. But at the moment, on the basis of the position statements and earlier documents, we need a lot more information. Otherwise, we don't know what we're giving evidence on. So can we please have the further written submissions so as to inform whether or not oral process is required?
Thank you. Ms. Pearson?
Just a comment, because I was one of the people who would actually quite like to be at a hearing to do with the noise issue. That arises because I was affected personally by the presence of large turbines close to Fairley, which ran at the offshore test station about 1.5 kilometres from where I live. And so I've got a personal feeling about this. So I think the difficulty for people who are not professional acoustics experts is that to formulate, written submissions up front can be quite difficult. It actually needs people to talk about these things, and I mean it cuts back into the whole thing about the procedural and policy positions as well, because one of the points that we're been trying to make in a lot of these wind farm cases is that the existing noise regulations, in our view, are not really fit for purpose for the size and scale of machines that we're getting just now. And therefore, we need to talk about that, that legislation needs updating and, as part of our submission process. And it's difficult to do that in a kind of written way, because we know it's something that's going on in the background with governments looking at it. All these things take so long to actually turn into something. And here we are, again, looking at a live proposal here for a, wind farm with quite big turbines close to a lot of people. So that's the reason why I would be supporting the, a hearing type setup. I know it makes it a bit vague for people who want it all cut and dried, but I think that's just the way it is.
Thank you. No, completely noted. I think for everybody, though, just to note, there needs to be a degree of realism about what this inquiry is about. So, we're talking about legislative or regulatory change. That's not something that's within my remit, looking at an individual proposal. But certainly if you raise it, it will be part of a pack of information that goes to the minister. Where I'm at is I've got your representations that refer to concerns about noise and vibration. And then I have a position statement from Fairley Community Council, which again refers to noise and vibration, low frequency noise and potential health impacts. But it doesn't go into any depth in terms of what exactly is the concern. What is it about this particular wind farm? What it is about the noise impact assessment that is being questioned? So for my purposes and for everybody else's, because the inquiry process is not one of ambush, it's one of openness and everybody understanding everyone else's position. So my feeling at the minute is that we have a written exchange, updating and more detail in terms of people's positions, particularly as we're talking about introducing perhaps specialist witnesses. I really need to know what they're going to talk about and why they're there, because my experience of this in the past, I don't want this to be a strategic chat. I would much rather it be focused on the particular wind farm and surrounding wind farms in question, and I need the detail on that. So I'm going to adopt Mr. Trinick's approach. I'm going to ask everybody for a position statement essentially in advance. On the back of that, I'll determine whether or not we require a hearing session. I do feel at the minute a hearing session is probably the way I'm going to go, and I'm just going to tell the applicant that now. My only concern is the last time I held a hearing session on noise, it was a very long session. I think we went from 9:30 to after 6 in the evening. So I would be looking at streamlining that hearing more and really focusing on the issues at hand. Mr. Grosvenor.
So yeah, we're happy with that. I think the point is that the concern was that the whole topic of noise would be just relegated to written submissions, and we fully accept the position of the applicant that obviously they need to understand the case coming forward, and we would be quite happy to provide, written statements of case, precognitions, whatever assist you to then lead up to a hearing session. And on that basis, we would certainly be happy to engage in the early stages in preparation for a hearing session. And that is the right and correct procedure to follow. But the concern was that we put in our written submissions and then just be left without a hearing session following on. That is our concern. And we can limit it down to the specific issues of this particular case, but the wider issues arising from this specific case would then automatically follow. And as Mr. Pearson said, that it is a case that people have had direct effects, and also those direct effects are concerns that would then follow on if this scheme is consented as well. And just jumping ahead slightly, this would then follow on to the condition session, which I know you haven't touched on yet, but you will be. So we would then sort of follow on into a condition session as well. I hope that helps you.
Yes, thank you. I just want to come back on one point. Having written submissions isn't a relegation. As I said from the beginning, whether or not we hold any process or which process, it doesn't dilute the importance of that particular matter. Mr. Trinick?
Right, so yeah, when you refer to position statements, what I have in mind is not simply saying we have an issue with noise, but to be very precise as to what the issues are.
Yes.
It's vital that we know the full case which is going to be made against us and what we have to face. And I'll just put down a marker that should you decide an oral process is necessary, I don't see how a hearing session is going to work. This is a technical topic which requires proper examination. So if you do decide to have oral process on noise, and we'll see where that goes, then I may be asking for an inquiry session. And clearly we're into timing issues here because we've had a week set aside for the inquiry, and time can get tight very quickly. Thanks, Phil.
Mr. Fryer, and then I'm going to come back to the issue of an inquiry. Yes, Mr. Fryer.
I was just to agree with the process that is now being suggested in terms of some detailed submission first and written statements, which then will hopefully lead to an oral session. I agree with Marcus in terms of whether that's a hearing session or an inquiry session. Noise is a very technical element, and whether a hearing session is suitable for that, and it may well be that an inquiry session is required. Thanks.
Ms. Holmes.
I think I've agreed with most of what people have been saying now, but what I want to point out is just that since the beginning, since we got this application, the applicants have tried to dismiss everything to do with noise and low frequency and guidelines, etc. And we feel this is something that should be talked about to make the process, the inquiry process, efficient, open and transparent, so everybody gets their say. And we're quite happy to have a hearing or an inquiry session. The only thing about an inquiry session would be the cost imposed on our community for providing expert witnesses, incur a great cost to us. I just want to put that forward. Thank you.
Thank you. Dr. Duckett, your hand's up. Did you wish to speak, or is your hand? No, okay. Right. I think it's important just to put down a marker for myself as well, that it's important for myself to understand where parties are coming from. And at the moment, I don't understand what the specific noise, vibration, infrasound issues are. With this particular case, I understand the wider strategic concerns about that, but I don't understand in terms of this particular case. So I would need some statements to understand that. In terms of an inquiry session, I've heard from Mr. Pearson about local people wanting to be involved, and Ms. Holmes, your point about cost. I would understand that if we had professional witnesses. So if the community council had a acoustic specialist, if CWP were planning on bringing along an acoustic specialist, I could see merit in an inquiry where particular points were being made. However, for the more general points about noise, I feel a hearing seems to sit better with myself. Is there any scope for a hybrid process? I haven't done this before, but I'm just thinking perhaps a hearing session followed by the inquiry and or the other way around with particular witnesses, Mr. Trinick?
Oh, if you get messy. I can see there's a merit in having local people who want to express views on noise coming along to the community hearing session and expressing those views without fear of cross-examination. There will be no cross-examination at the community hearing session, obviously. Yeah. In fact, I doubt we'll be saying very much. We're there to listen. That's what it's for. But where I think the expert evidence needs to be dealt with, perhaps in a separate context, and through a short, sharp inquiry session.
Okay,
thanks, sir.
Okay, so on noise, what I'm going to do, I'm going to write to parties and ask for their positions, very specifically what their positions are. I'd also want to know where you agree. I don't just want it to be what you don't agree on. And there will be, if I determine to have an oral session, there will be a requirement for a statement of agreed matters. I like the idea of including local people in the sense of local concerns about noise. And so I would be very open to having yourself, Mr. Pearson, instead of participating in, say, an inquiry, you could come along to the community hearing session and talk about your noise concerns in that format. Are people in agreement with that process? I understand that there's a bit of ambiguity and that you're not sure if it's going to be a hearing or inquiry yet. But I'll make that determination very quickly. Ms. Holmes.
I think because we've lived through the Hunterston wind turbines and the ill health that caused chaff, and communicating with other people in the same, having the same problems and finding that they're not heard. I think it's important because we feel that we're deep in this thing and we know all the issues, etc. We've forgotten to maybe, I can see where Mr. Trinick would say that he doesn't know where we're coming from. So yes, I agree. The written statements or positions that we're coming from will be very useful. I'm not very sure. You did say yourself about ambiguity. I'm not very sure. I mean, definitely we need a hearing. I do not think that anybody like myself would be averse to being cross-examined about anything that we're submitting for an inquiry. So, yes, if we get a hearing session, all very well, that's good. I just don't want whatever is decided today to limit what we're able to do in the week in February. So I'm very aware that I don't want to miss anything that's going on here this morning and somehow stop us from being able to say anything about in any of the sessions, you know, when they do. So
yeah, don't worry. No matter what happens, you'll have a chance to say or be involved in these processes.
Thank you.
Right. No problem. So I think we've agreed now. I'm going to ask for further submissions from everybody in terms of what your specific concerns are, and then I'll decide on a hearing or inquiry. I am, after what you said, Ms. Holmes, I'm now thinking about an inquiry. Quite, you know, seems if you're happy to cross-examine and other witnesses are, Mr. Pearson, you could come to that or you could come to the community hearing session and air your noise concerns there. Would the community hearing session work better for yourself?
I think I'd be happy enough at the community session, and would rely on the community council to put the points solidly if there was an inquiry, rather than, you know, sort of double up the numbers on the same issue.
Thank you. That's good. Now, at North Ayrshire Council, noise. I have found it useful to have an environmental health / noise specialist at any oral session. So I'd like to include you. Are you agreeable to that?
Sorry, Mr. Evans. Yeah, I was just contemplating there. Yeah, that wouldn't be a difficulty for the council to provide that representation.
Okay, thank you. Okay, we're moving on. Oh, Ms. Gould.
Okay, I do fully understand that we have to concentrate on this case and this application. I'd just like you to confirm that any hearing or inquiry would also include noise from the Bess, because everybody else has talked about wind turbines.
Yes.
So just be certain that that would be followed through with as part of the hearing or inquiry.
Right. Well, someone would have to, within their response, mention noise from Bess.
That's fine. That can be done.
Okay. So are you
So
saying,
long as we make certain mistakes,
yeah,
it would be included. Is that what you're saying? That's fine. Thank you.
Yeah, I'll just check here. So would you want to participate yourself, Ms. Gould, in the community hearing, for example, where you could raise that point?
Yes, I would also like to discuss that with Mr. Duckett, and we would decide if he wanted to, or if I wanted to raise it. Thank you.
Right. Mr. Grosvenor.
Yeah, just quickly, we have got some sort of knowledge of Bess. Certainly it would be helpful perhaps if Valley Community Council liaise with the other parties concerned about the Bess noise, and can certainly support them in that, and bring it under our umbrella, or let them do that individually. But we've got no issue with the Bess side of the noise case as well.
Okay, thank you. That'd be much helpful. Okay, we're looking at ground conditions, peat and hydrology. Now, I did have no further procedure. However, I have noted, and we've had correspondence from SEPA, that they still have a holding objection. So, Mr. Trinick, do you have any update on that particular issue?
Discussions are continuing, so I suggest you might want to put in a provision for written submissions.
Yeah.
Along with the rest. I think that matter will be resolved this evening.
Okay, thank you. Mr. Thompson. I'm afraid you're on mute, Mr. Thompson.
Can I suggest that the ground conditions and hydrology are linked into the next meeting, which is flood risk, water resources, etc., because the two are inseparable.
Mm-hmm.
And I think that if you cut it down for local residents, it might be something that would be discussed at the community hearing that you're suggesting.
Okay, so I've got down for issue 9 in hydrology flooding that there be impact potentially on the Munnock homes. So who, if anybody here, would like to be involved in that if I do further written submissions?
I'd like to be at an oral hearing. As I say, we've had problems in West Kilbride where the gas board had underestimated the flow of water off the hills, the drainage, etc. And it's been be satisfactory to feel that this has been addressed in inquiry, so that we don't have further problems if we pardon the pun downstream.
Okay, so sorry, Mr. Thompson, you said a hearing. Would you like, my feeling here is we could deal with this with a written exchange, and then if you want to raise it further, you could bring it up at the community hearing. Is that acceptable to you?
I would require detailed plans from the applicant so they could check the ground floor, the drainage courses they're proposing, etc., etc., if we was to give you a written work plan.
Okay. What I'll do, I mean, I'm thinking I'll do written submissions and I'll include SEPA and yourself, Mr. Thompson, for issues 8 and 9. And I can get the applicant to liaise with you in terms of any particular groundwater terrestrial movement of water that you need to look at.
And it'd be the drainage from the roads, so
yeah.
There's quite a lot of expertise in this group. You know, you're saying, oh, I need provisions. I'm a retired surveyor. There's loads of other people with equally good qualifications that are talking to you today.
Yes. No, I fully appreciate that. Thank you, Mr. Thompson. Ms. Parsons.
I would like to submit more information regarding peat. I don't know whether it could be done at the community hearing or not, or
sure, just
further written submission on this.
Yeah, well, I think peat's an interesting one because it kind of covers a lot of issues. You know, you're going into also ecology, nature conservation, and climate change. So is there a particular is it loss of peat that you're interested in? Is it the carbon balance from peat?
It's the amount of peat. You know, having read the peat depth survey, I'm a bit concerned about some of that.
Okay.
Yes.
What I'll do, I'll include you because SEPA's holding objection actually refers to peat and restoration, although it is something that Nature Scott are also involved in. So, Mr. Trinick, what I'm proposing here is I'll have further written submissions covering the hydrology, flood at risk, and peat. I'll formulate the questions for that, and there'll be an exchange between parties. And Mr. Thompson, if you want to raise it further, there's the community hearing session that you could discuss any of these matters or at least give your view. Does that sound like a...
That sounds fine, sir. Yeah.
We'd need to do, as Mr. Marcus is saying, with his party, you know, he likes to know what he's talking about before the question. If they're sending the details so we can see what we're actually talking about, it's equal benefit to both parties.
Okay, well, I think, and apologies for speaking on behalf of the applicant, but the EIA, so the Environmental Impact Assessment, has chapters that cover this in technical appendices. So all that information is already in the public domain. I don't know if you've managed to look at that, Mr. Thompson.
I looked at the documents that were placed in the local library, and you'll see in my letter today, which I said personally, I referred to somebody's matters at that time.
Okay, well, what I'll do, we'll do further in submissions, and what I'll do to make it more helpful, I'll point to which areas, I'll maybe ask the applicant to help me with that, point to particular areas within the EIA that you could look at, Mr. Thompson.
That'd be helpful, but there's enough to prepare plans to written work, because I think it's easier to relate the plans to the ground than it is to writing some of the photographs.
Okay, sorry, Mr. Trinick, could one of your team perhaps just send me some information on where you think Mr. Thompson should look within the EIA? Just an email to Hazel Bailey.
Well, yes, we can, sir, but I'm still a bit unsighted on the precise issues that Mr. Thompson wants to address. So what I suggest is that we arrange a call between Mr. Thompson and the EIA team or somebody on the applicant side so that the extent of his issues can be understood and then we can point him in the right direction.
Yeah, thank you. And if we do the further written exchange, then I'll also understand further the concerns. Ms. Gold?
Yes, I have looked at the section of the EIA about water, and I didn't actually find anything specific that talked about how they were going to mitigate any risk to the 7 homes here. So I would like a little bit more information about that, please, from the applicant.
So if I include you within the further written submissions as well, Ms. Gold?
Yes, that's fine, thank you.
Yeah. So, sorry, do you live in one of the Monarch homes?
Yes, I do.
Okay.
I live at number 4 Monarch. And along with other neighbours who are not joining with this, are very concerned about flood risk.
Yeah, well, I appreciate that you'll be representing them, I presume as well, so.
Thank you.
Yeah. Right.
Sorry, Mr. Edwards, I just wanted to point out, I'm also a Monarch resident. Yeah, just for clarity. Mm-hmm.
I will also include you in the further written submission then, and then you're all encompassed within the same process. Okay?
Thank you very much, sir.
No problem. So in terms of ecology, nature and ornithology, I've said no further procedure. Is everybody content with that? Yes. Landscape and visual impact, including aviation lighting. Ms. Parsons.
Well, just going back to ecology, nature conservation and ornithology, I've kind of come to the process a wee bit late. So I've been asked by the Friends of Clydemuir Shield to come along and help with this. So there are some issues I have with the ecology and nature conservation. I wondered if I could submit some further written information on this, please. Would that be possible?
Just 1 second, sorry. Apologies, just 1 second. So it's a difficult situation because we have positions of parties to try and understand where they're coming from. And it's difficult when we start introducing new matters at a later stage in the process. So I'm just trying to figure out if the regional park had ecology or ornithology concerns originally.
Yes, well, I mean, basically, we said it would have impact on the natural capital, the regional park, which is basically the ecology and the ornithology. So, yes, I would just like to provide a bit more information on that. You know, having read the EIA, I have concerns now.
Okay, well, I mean, I don't actually, it'd be useful for me to understand what you mean by how this proposal would affect the natural capital of the regional park. Mr. Trinick.
Sorry to push back a bit, but I'm going to. Consultation period has been and gone on the application, and you've had a position statements. This could arise for any single issue. I've suddenly thought of something, I want to say something about it. That's not the way the inquiry process works. And I think we need a bit of a discipline here. The Clydemuir Shield Park has not yet revealed, despite the fact it was consulted and made a consultation response, any issue about ecology and nature conservation. The phrase natural capital covers some things much wider than ecology and nature conservation. So I would resist any further process at all on this issue for the sake of Clydemuir Shield Park.
I'm just wondering, Mr. Trinick, would it be acceptable if Ms. Parsons made these points in the community hearing session?
Oh, that's quite a separate thing. Anyone can say anything in the community hearing session. Perfectly happy with that.
Well, within reason, yes.
Well, within reason, yes.
Dr. Duckett and then Ms. Holmes.
Sorry, I didn't realise. I thought we'd moved on to the landscape visual thing. I didn't realise my hand was still up. Sorry.
No worries, we're about to come on to that. Ms. Holmes?
Just really to say, I'm sure in Fairlie Community Council's submission, we put in about the ecology and landscape, etc., and environment and raptors and everything. So I don't see any problem personally with Mrs. Parsons, you know, putting in more information. It's basically on a topic. You're asking us for more information about noise and vibration and our issues and everything. That I would have supported Mrs. Parsons and taking part in the ecology thing.
Sure. I think the problem arises in that the process is really supposed to be front loaded. And as Mr. Trinick has said, using a term like natural capital or ecology in a wide sense, it's not clear what the exact issue is with this proposal. You know, if someone said, and this is just a hypothetical example, I don't agree with the bird survey because actually I've seen and have evidence of X raptors on the site. That's very specific, and we can then look at that. Whereas just saying impact on birds generally, it's difficult for us to understand what the exact issue is. And we're trying to program this in terms of inquiry time as well. So, you know, raising issues at a later stage are less than efficient. However, I do think, Ms. Parsons, you could raise this within the community hearing session. Would that be something that's amenable to you?
Yes, I'll do that. Yeah, thanks.
Okay, moving on to landscape and visual. Mr. Trinick, I've got down here 2 days for a hearing or 3 days for an inquiry. I really need to know witnesses here, because from the council's point of view, North Ayrshire Council, you're saying written submissions. They're saying written submissions would be the best way to approach this. So what are your thoughts, Mr. Trinick?
We'd like an inquiry session, sir, but I think it won't take more than 1.5 to 2 days, certainly a maximum of 2 days. We think this being a principal topic for the inquiry and one that interests local people as well as consultees, it ought to be properly explored.
Okay, and you would have one witness, is that correct?
Mr. Neil Ferber will be my witness. I have one witness.
And who would you expect to be in that inquiry session?
Well, I would hope the North Ayrshire Council might turn up and speak to their objection. Otherwise, well, it's up to other people. I'm surprised to see CWP on the list for this session. I'm not quite sure why, but Mr. Fry will no doubt tell us. Otherwise, I would hope that an umbrella could be formed over local concerns if they want to take part in this session. And equally, a community hearing session would seem to be the ideal place for local people to meet their views. No.
Okay. North Ayrshire Council, just like to come to yourselves and your thoughts on landscape and visual impact.
Thanks, Mr. Edwards. Yeah, I mean, you've confirmed the council's position, which remains the case. I think that the council's participation in a hearing session, we would have no objection to that. I personally don't see the necessity for an inquiry session in this matter, given the topic of discussion. And I think the points we made previously about community representation are well made in respect of professional advice. So I think if you sort of decide that a hearing session is required, we'd be perfectly happy to attend that.
Okay, well, let's just focus down on an inquiry session to begin with. If there was to be an inquiry session, do you have an in-house landscape architect or would you hire one in to be a witness?
The council has no internal landscape architect, and we would not be hiring one in for purposes of an inquiry session.
Okay, sorry, just to understand this further. So would it be the planning officer that would be involved in an inquiry session then?
It would be myself and my colleague, Mr. Davis, who's present today.
Okay. Before we go further in this, Mr. Lasprince.
Yes, hello. I'm assuming that the initial written objection that I made, which amongst other points highlighted the landscape visual effects, is duly noted and carried over, and it's not necessary to repeat it, and that's why people like myself are not on the list of participants in those steps that you've outlined.
Yes, I mean, you're very welcome to take part in an inquiry or hearing session on landscape and visual impact, but you're correct. Your written submission carries the same weight as any other information that's been submitted. So I will take it fully into account, and your points will be covered in the report to Scottish ministers.
Thank you. That's all. Thank you.
Dr. Duckett, you had your hand up previously about this matter. Did you have something to say?
Yeah, it was just I think like Mr. Lesperance there, I think it's quite a technical issue, but I'm wondering whether I haven't seen any issues surrounding, particularly, I'm sorry to go on about the Bess, particularly things like the lighting around the Bess. From what I see at the moment, we have dark skies above us in terms of, using a NASA scale, for example, we're on a relatively low.
I'll just stop you there. I'll just stop you there, Dr. Duckett, because I don't want evidence today, but I understand what you're saying. You're concerned about the lighting in dark skies.
I understand that perhaps the place to raise that would be in a community meeting, the community hearing. So
yeah,
that's why I didn't put my hand back up again.
Okay, no, noted. Okay, and Ms. Holmes.
It's concerning, I think, for a local community if you're going to have an inquiry session on something when you've got the applicant who's able to afford bringing in experts, etc., and King's councils, etc. And on the other hand, you've got a cash-strapped local authority and a wee community council with very, very little in funding. I just want to make that point. And I don't know how you can alleviate that problem. It puts the community and other people at a disadvantage, I feel.
Noted. Thank you, Ms. Holmes. Today is not the time to get into the financial economics of how energy consents work, but your points are noted. Mr. Trinick?
No, sir, I won't respond to that.
Okay. I mean, Mr. Trinick, you've heard from North Ayrshire Council that they're not going to bring a landscape witness. Are you still content to go ahead with an inquiry session in those circumstances?
Yes, sir, I am. It's up to North Ayrshire Council to decide whether they want or not they want to object to the application. They know the consequences of objecting. The matter goes to an inquiry. Fairness goes in all directions, sir. It also goes in the direction of the applicant, which, although people may laugh, has made a considerable investment in this application and is entitled to fair process itself. We want an inquiry session. Thank you.
Okay. Well, I agree, North Ayrshire Council, you've objected. It's particularly on visual grounds, not landscape. So if we have an inquiry session, I think we will have an inquiry session, but there will be a statement of agreed matters. So, hopefully that will narrow the focus down to particular viewpoints or methodology, whatever else parties might be interested in. I take it there's nobody in the community wants to come together to provide a witness or talk about landscape and visual. Instead, you would come to the community hearing session and air your views in terms of aviation lighting, aviation lighting flicker, I think has been mentioned as well, and the best lighting. Is that content for everyone? Yes, Ms. Gould.
I think that's something that I would want to consider further, because I do agree with the point Ms. Holmes is making. I understand this is not the forum for that discussion, but I do feel that, we rely on North Ayrshire Council for the other issues that we all feel that are going to be brought to this inquiry, but perhaps I would like to reflect on whether I wanted to be involved in that. Thank you.
No problem. Well, as I say, the note of this meeting will go out and everybody will have an opportunity to opt into any of these processes should they wish after the event. It is useful for us to know in advance, but there is that opportunity.
I fully understand that you need information in advance. Thank you.
Yeah. Ms. Holmes, and I'll come to North Ayrshire Council.
Sorry, I have nothing further to add. It would have been more about the financial aspect. Okay. Stop there.
Mr. Finlayson.
Thanks, Mr. Edwards. You've made your position clear in respect to your intentions to have an inquiry session. Could I ask for clarity on the purpose, or why you consider an inquiry session would be necessary, and what it would add that a hearing session could not?
Well, hearing sessions I find are very useful when we want to have a wider discussion with parties, and obviously I would lead that. The inquiry session, however, as you're aware, is more forensic and can get down to the nub of the issue. So it might be the methodology, it might be why a particular viewpoint is considered to be significant rather than not significant, and that could be down to a matter of judgment. And sometimes it's good to have that cross-examination to understand why parties have come to the view they have, and also have an opposing view. Sometimes in a hearing, I might not be able to pull that out. So that's why I'm content with an inquiry. Does that make sense, Mr. Finlayson?
It does, Mr. Edwards, but I disagree with your interpretation. I think a hearing session could adequately cover all matters.
Well, I think it has been used, but in this case, the applicant is, asking for an inquiry, and I think the fact that the council has come to a decision to object on visual grounds without a landscape architect, I think that merits some investigation through an inquiry process. Mr. Trinick, any further comments?
You just said, sir, what I wasn't brave enough to say. That if the council decides to object to an application without proper professional advice, then that matter needs to be looked into in an inquiry session.
Ms. Holmes?
The Community Council also made a big thing in their objection about visuals. So I don't know whether you would want us as part of the inquiry session and be cross-examined, because it seems obvious to us from actually the photo montages just how absolutely awful the views are going to be for some people. And if you want people to talk about the remoteness of the area, etc., local people can do that.
Sure. Well, as I said to Ms. Gold, I have no problem if perhaps you want to nominate one person in the community, or yourself, Ms. Holmes, who could take on the community views in terms of landscape and visual and be involved in the inquiry session. We'll come back to that. Mr. Thompson?
I'd just like to hold up a document here, which is the Clyde Muirshield Regional Park Central Area, and it marks out significant sites, and one of them is a Knockandoo viewpoint, which is right in the centre of the proposed site. So it has been already acknowledged as being of significant visual significance.
Yes, thank you, Mr. Thompson. Mr. Finlayson again.
Thanks, Mr. Edwards. Just to respond to Mr. Trinick's point, the council has no difficulty in representing itself in respect of any procedural way, Mr. Edwards, and equally is perfectly confident in the robustness of the professionalism that was undertaken in the assessment of the application. But I think that, to me, the benefit is of a hearing session would be in respect of discussion and the benefit to community representation at that process. And in essence, we're talking about a difference, essentially, to my mind, of whether cross-examination and further professional advice is required at an inquiry session. That's my only concern in respect to process. But should you, Mr. Edwards, consider differently, then the council will participate in any way considered necessary.
Thank you, Mr. Finlayson. Mr. Riddle?
Thanks, sir. I would wish the inquiry to consider at this point the relevance of the photomontages produced by the applicant to the appearance of the wind turbines when they're actually operating. I think that's an issue, if I remember, Mr. Trinick and I discussed many years ago.
Okay, as opposed to them being static.
That is correct, sir.
Okay. Ms. Parsons?
Yes, I would like to be involved in landscape and visual too, just because it's such an important landscape as part of the regional park.
Okay. Sorry, Mr. Riddle, your hand's still up. Are you coming back in?
Sorry.
No,
I'm sorry.
Okay, so I'll reflect on this, but at the moment, I still think an inquiry would be the best way forward in terms. Sorry, Mr. Trinick.
I'm looking at Rob Fryer, thinking, is he going to say anything?
Oh, well, from CWP, I think you mentioned you wanted to be involved in landscape and visual, but I think earlier today we've agreed that we'd have a bespoke session with CWP. Ms. Fryer.
That was as we discussed previously. Within our position statement, we said we were not objecting to the landscape, but we just wanted to have the right to be involved in that part of the inquiry. So we would still wish to have that, if that would be possible.
Well, now is the time, I think it's 2 weeks after this note of the meeting goes out, you need to opt into a process, Mr. Fryer. So either now you say you're opting in, or you can tell me 2 weeks after this note goes out.
Yeah, if that's okay, I'll let you know in 2 weeks' time. About the element of having a separate session with ourselves. My understanding was that was primarily to do with noise. I don't think we were going to necessarily cover any of the landscape elements.
Not so noise is bespoke, separate session. Your session would be to do with wake disturbance and all those other efficiency issues.
But that wasn't involving in terms of the landscape.
Yes. Not involving landscape. Yes. So
that's correct. Yeah, that's fine. That's fine. Sorry, sir, I misunderstood. That's fine.
Yeah.
Thank you.
Okay. What I'm going to say is, we've definitely got the council and the applicant involved in an inquiry session. If the community, Ms. Holmes and others, want to rally and have one person represent them, you can let me know within 14 days of the note that you'd like to participate in that. Otherwise, within the community hearing session, you would be able to raise landscape and visual concerns that you have. However, I would make a distinction here. In the community hearing session, as Mr. Trinick has said, it's more likely that you'll read out your concerns, and I may have some questions, but the applicant likely won't have any questions or won't be involved heavily. So you won't be able to cross-examine, for example, the applicant's witness. So that may be a reason that you want to be involved in an inquiry session, but I'll leave that to you. Okay. I'm going to move on now. Archaeology and cultural heritage. There might be crossover with landscape and visual impact, but otherwise no further procedure. Is that agreed? Mr. Trinick?
I hope there's no crossover. They're very different topics. I wouldn't want to see cultural heritage creep its way into the landscape and visual session.
What I mean is that some of the representative viewpoints might be taken from a cultural heritage asset. So
okay.
Yeah.
But they are very different topics.
Yes. Traffic and transport. Mr. Thompson, you were going to talk about the internal roads, but part of the community session, so no further process here. That's agreed. Socioeconomics, I don't think there's any need for a bespoke hearing session or written submissions on that now. I think the community hearing session could take that on board. Is everyone agreed with that? Okay. Now, aviation. We've already heard from Prestwick Glasgow Airport that they would be happy for further written submissions on aviation. Glasgow report and NAT safeguarding. So, Mr. Blaine, I'll get you to come in.
Yes, thank you, sir. As you'll be aware, Glasgow Airport is a statutory consultee in this application and action relating to the impact of the proposed development on the airport's radar systems, and also that further assessment is required of the impact of the proposed development on the airport's instrument flight procedures. These will require third-party technical assessments to be undertaken before the airport can fully assess the potential cumulative impact of the development and consider whether mitigations are in fact available. The airport is willing to engage with the applicant and has indicated that willingness to engage with them. However, at the time of this hearing, further work is still required. So the objection is maintained to allow those necessary assessments to be undertaken. You had suggested in your proposed note, and I understand that Glasgow Prestwick Airport agreed with the allocation of this topic to further written submissions. I think at this stage, given the assessments are still ongoing, and if there remains a substantive objection by Glasgow Airport, then we would be looking to lead third-party technical experts as well as at least one factual witness from the airport. That, in my respectful submission, does not sit well with the written submissions process, and a short period of time should be allocated within the inquiry sections of your timetable, sir.
Okay, if I hear from NAT safeguarding then, and then we'll come back to this. So I think it's Alistair Old.
Yeah. So very similar to Glasgow Airport's position. I think our position is slightly simpler in that we don't have the IFP issues. We still have an outstanding objection based on radar issues. We expect, with engagement with the applicant, that this development is ultimately mitigatable, but there is significant work to be done between now and then. So I would hope that things are simple enough when we get there, the written submissions are sufficient. Okay. But there is a chance that things don't go quite as smoothly.
Okay. Mr. Trinick, I'm interested in timescales here, because it sounds like there's ongoing assessments. So the timetable I set out for further written submissions might not fit with that. So I'll let you tell me what's happening.
Well, Mr. Old and Mr. Blaine put the position perfectly fairly. Discussions are continuing, will continue. We will expedite them. So I think you might be looking at a written exchange slightly later than the other written exchanges, but nevertheless, an initial written exchange to inform you about the need for oral process. I can't give you a precise timetable on that, but may we get back to you with a timetable within 7 days of this meeting?
Yes, so that would be very helpful. Thank you. I'll note that down. 7 days for timescale.
But I think there's an anticipation that certainly with NATS, I think it's reasonably simple to reach an agreement to enable the withdrawal of the objection. For GIA, we'll wait and see.
Okay, so and for GIA, you said a short inquiry session might be required. You've talked about 2 witnesses, though. And if the applicant also has 2 witnesses, and maybe Glasgow Prestwick Airport's coming in on this as well, I mean, I think we're talking at least a day. Mr. Trinick?
I've never known a short aviation inquiry session to go on a bit. So what I'm worried about is that if we do have to have an inquiry session, trying to fit it within the week of the inquiry is going to be very difficult indeed, if not impossible. I think if you will allow us that 7 days to come back to you and tell us where we are and where we're going, Mr. Blaine and the applicant can communicate.
If I can come in at this point, so yes, happy to have those discussions. I'm obviously not in the same room as Ms. McDonald, so we there are different lines of communications. We can take that away, but in the meantime, would be reserving my position in terms of for substantive further procedure. And I take Mr. Trinick's point that there perhaps there's optimism in my assessment, but one day is still short relative to other processes that have gone on in these types of inquiries. But happy on behalf of the airport to have these discussions as Mr. Trinick has suggested.
Okay.
I also have comments in relation to conditions, but I'll wait until the end of the agenda to raise them, sir.
Okay, thank you. Right. In terms of shadow flicker, I think some locals had raised the point about nighttime effects from the lights. That could be captured within a community hearing. Are parties content with that? Yes, Mr. Trinick.
I'm not sure we're talking about shadow flicker at all, sir. If it's about nighttime lighting effects, that's not shadow flicker.
No,
that's simply lighting effects. That's very different.
Yes. Well, I think that could be, well, if the community do participate in the landscape and visual impact assessment inquiry sessions, which would include aviation lighting, then that matter could come up there and or it could come up in the community hearing. Yes, Mr. Riddle. You're on mute. Sorry, you're on mute, Mr. Riddle.
You hear me now?
Yes, thank you.
Yes. This is not a shadow flicker issue. This is a completely new issue which has come up with these very tall turbines and the requirement to put aviation lighting on them. And I don't think this is a matter which has been considered. Nature Scotland has considered it, but I think it needs to be raised as an issue.
Okay, and you're content that either the community being involved in the landscape and visual impact inquiry session, or that this matter could be raised through the community hearing session. Are you content with that, Mr. Riddle?
Yes, I could raise it during the landscape and visual impact assessment. That's fine, sir.
Yeah. So through the hearing, you could raise it?
Yes, sir.
Yeah, okay, thank you. Okay, just moving on, telecoms, no further procedure. Miscellaneous issues, I have two written submissions here. One is confirmation regarding the tree felling. Now, I can't recall which party raised that, but would anybody, I've got I've got local residents involved. Is there anybody that would be involved in tree felling? No, in that case, Mr. Thompson, yes.
These trees were planted under an EU grant system.
Yes.
They're quite important with the water control. And so this would be something we'd be interested to see what they're doing, because the tree felling is going to have effect on the rest of the system.
Okay.
Mentioned in my letter.
Yes, thank you for reminding me. Ms. Gold?
I think I've mentioned also, along with Mr. Thompson, about the fact that the trees planted there. Well, first of all, in the information provided by the applicant, I wasn't clear how they were going to build it without cutting trees down when I walked up the hill to see where they were proposing to put the Bess. The other aspect is to fully understand, which I'm afraid I don't at the moment, how public money can be given for a tree planting scheme and then public money also be given to, develop a wind farm on the same land, how that is, is considered. So I'd like to know a bit more about that from the applicant, about the trees they're going to cut down.
Okay.
Thank you.
Ms. Parsons?
Yes, I too would like to be involved in the tree felling discussion.
Okay, I mean, I'm quite content to put together a further written submission on that with some questions regarding the points that have been made in reps. Are you content with that, Mr. Trinick?
Yes.
Okay, we've talked about, well, we'll come back to that, sorry. There's two other miscellaneous, and one is a community hearing. We've agreed with that, and we'll hold that. Then we're on to cumulative impact. Again, I don't think we need any further process, but that may come up in landscape and visual impact in the inquiry session. Yes, Mr. Trinick.
There was an issue raised earlier on fire risk, and you said you would discuss that under miscellaneous.
Yes, I think now it's sitting nicely within the community hearing session.
Okay, that's fine.
Okay, summary of mitigation. We don't need to have any sessions on that. And then a half-day hearing session on conditions and or any legal agreements that we required. Dr. Duckett, yes.
Yeah, sorry, just on the fire issue. This is a complicated one, and I'm wondering to what extent we need genuine expertise to look at the very significant risk, particularly of the Bess. Although we've recently had a wind turbine blow up just within views of the house, so I personally think we could get fire experts involved somewhere along the line.
Okay, well, there are there's obviously some statutory consultees involved in this process as well. I'm tempted that in a community hearing you might not get the answers that you're looking for, so I might put out further written submissions in terms of battery energy storage and fire safety.
Yeah, I mean, I can talk about the chemistry and physics of it, but you know, there's too many of these going on fire at the moment around the world, and they release very nasty things. So I think appropriate expert advice would be useful here.
Okay, so I involve yourself, Dr. Duckett, and the statutory consultees and the applicant. Right. Mr. Fryer, you've had your hand up for a while.
Yeah, sorry, it was just to go back a couple of points there, just on the cumulative impact. You mentioned about in relation to the LVAA, but clearly that needs to be involved in noise as well.
Yes.
Yeah. Okay, that was the comment.
Yeah, it's kind of an overarching issue. You know, it's been captured in the EIA at the end, but it does come within each chapter, you know, itself as well. So for the conditions and legal agreement, I've got half day down for a hearing session involving the applicant, the council, and community wind power. I'm assuming, Mr. Blaine, you want to be involved in that as well?
Yes, so if mitigations are available, they will need to be conditioned, and again, they could drift into more technical matters, so it may be appropriate at this stage to anticipate the involvement of the airport, Glasgow Prestwick, NATS, etc. But that's the detail is speculation at this stage.
Of course, and Mr. Grosvenor, you may or may not be involved in the capacity of the noise conditions.
As I intimated earlier, we would want to be involved in the noise conditions as part of that session.
Okay, well, I think we're content, Mr. Trinick, or you can, Mr. Fryer, yes.
Yeah, sorry, just to confirm that we do want to be part of the conditions primarily for the noise. That's basically the cumulative elements, financially involved properties, and the like, and those limits that are associated with them.
Okay, yes, and also there was talk about some kind of either removal or suppression of 3 turbines in particular, and that may or may not be a mechanism through a condition might be used. So,
agreed. Yeah, that's fine.
Ms. Holmes? Sorry, you're on mute.
Can I ask what Mr. Fryer means about financially concerned properties? Is that the term you used?
I used financially involved.
Pardon?
I used financially involved properties.
Oh, right. Okay. Does that mean properties that have been bought out and signed non-disclosure agreements by the developer? Is that, or am I just?
That's not really for today. I don't know what hasn't been, but I'm aware that within the noise assessment there were properties that are financially involved and classed as such.
Yeah, well, we can cover that in the condition session if required, and the noise session. Okay, well, I think we've got handled now on the issues and the processes, and I can capture that within the note of this meeting. Yes, Ms. Gould.
I just want to ask, in the conditions, would there be safety conditions?
With respect to what? Because there's
things fire, because I may be wrong, and I'm sure you could put me right on this, but as far as I understand it, there aren't specific fire regulations for Besses. They just come under general fire legislation. Is that correct?
Well, yeah, that would be something that we could bring up in the further written submissions. It's not, I mean, I can't confirm or not that, and it's not for the applicant to do that just now, because this is a procedural meeting. But
my question is, would things like fire mitigation come up in conditions? That's my question.
Well, I can only speak from my personal experience that I have applied fire conditions, but whether or not those conditions are applied in ministerial decisions is a different matter.
Okay, thank you. I just wasn't clear on that. Thank you.
Okay. Dr. Duckett, your hand's still up. Is that just as a... Okay, thank you. Okay, for all of the oral sessions, I'm going to seek agreed matters from those participating, with the applicant taking the lead on preparation and including other parties. Is that agreed, Mr. Trinick?
Yes, sir, that's fine.
Okay. The applicant will also be asked to work with other parties to prepare a set of conditions using the ECU standard conditions as a starting point. Those participating in the conditions hearing session should be invited to comment on the conditions, and statutory consultees should also be invited to comment on any revised conditions that would affect their area of interest. For my purposes, it would be beneficial to have the conditions and definitions provided in a spreadsheet with separate columns for each party making comments. Is the applicant agreeable to organising this?
Yes and no. We're very happy to draft some conditions and initially to share them with North Ayrshire Council as the enforcing authority for conditions. So that'll be the primary focus in the first instance. Once we reach a point with North Ayrshire Council of not making much more progress, although hopefully we'll agree all the conditions, then we will share them with other parties. The exception to that is for Glasgow International Airport, where there'll be a separate loop, and also Nats and Glasgow Prospect. But what I don't want is to have a spreadsheet with 17 columns, which will get completely unmanageable.
Yep, no, understood. No, that makes sense. Thank you. Mr. Fryer.
Marcus, I'd just like to add, could we be party to the noise condition, please, so that we can have an acceptable cumulative noise condition?
Of course, Rob. No problems at all.
Thanks, Marcus.
Okay. The requirement for statements of agreement, conditions, and the inquiry and hearing documents for each party will be confirmed in the note of this meeting. So, moving on to item 7, dates and location and likely duration. Now, up to 5 days for oral sessions is currently anticipated, and we've reserved the week of the 23rd of February 2026 to accommodate the inquiry. I'm happy to begin sessions as early as 9:30 and finish at 5, with breaks depending on how witnesses and I are faring. An evening session could also be accommodated if required, for example, for the community hearing session. Looking at the oral sessions we've agreed upon, do we think the week is sufficient? Now, if we just cover the matters now, so I think now we're saying landscape and visual impact assessment is 1.5 to 2 days.
Yeah.
If there's a noise session, that would be a single day.
Well, I'm not sure about that, so I want to see what the written submissions throw up. Because it's a bit like aviation, noise can go on for a long time. So I withhold judgment on that.
Okay. So aviation, again, could be a single day.
I doubt that very much, so I think if we have an aviation inquiry session, it's almost a separate week.
A week, okay.
No, I don't mean to take a whole week, but we won't do it within the first week.
Oh, yes. Yeah, that's what I'm trying to figure out now. Then we have the policy hearing session, half a day, probably less, but we'll anticipate half a day. The condition session, in my experience, that can just be a matter of an hour, depending on where parties are at. So
if it helps, I think if we just look at landscape and visual and policy and conditions, looking at a maximum of 3 days.
Yes.
We then got, assuming we start on a Monday, 2 days to play with. That might be enough to fit noise in, but certainly not noise and aviation.
Yeah, yeah. And we've got the community hearing session as well, which I would give half a day for just in case.
Well, you say that, sir, but would that not be an evening session? I think people at work.
That's what we're going to discuss here. So it could be an evening session, in which case, yes, we could knock that into the evening. So we're looking at 2 days for LVIA, 1+ days for noise, 1+ days for aviation. It's 4, and then half. So 5. We're on 5, but if noise and aviation are more than a day, then we're looking at a second week. So I suppose my question is, are parties available? Oh yeah, Mr. Finlayson.
Sorry, Mr. Adams, I'll come back to you after you ask the question that you're about to ask. Thank you.
Well, it's to do with people's availability in the week commencing the 30th of February. Well, actually, sorry, it'll be the 2nd of March, I think. The following week. Well, I'll put that in the note of the meeting, but yes, Miss Holmes.
If it runs into the first Thursday in March, I have another appointment if I'm involved in anything. So I would ask you to avoid that if I'm taking part in anything. So it's just the first Thursday in March. I don't know what that date is offhand.
Sure. Yeah, no problem. We can work around that if required. I think this is all going to come down to, sorry, yes, Miss Gould.
You're just saying the community hearing. Was I right in understanding you saying that would just be in one evening?
It could be.
I think there's an awful lot to discuss in the community hearing for it just to be one evening.
Sure. Well,
I understand the evenings. You might feel evening is the best thing so that people can be available. But I think I'm getting this feeling at the end of this meeting that the community hearings seem to cover quite a lot of different topics that people wanted to raise, and it seems to be just shoved into one evening. So just feel a little uncomfortable about it.
Not at all. I think originally I thought half a day, and then we thought,
yes, sounds quite good.
Would it be more amenable for everybody to hold it in the evening? Now, I suppose that's my question to those of you that live locally. Would you like to participate in a day session, or would you prefer an evening or evenings?
Well, it's more whether it's in the day or the evening. I'm more concerned with the amount of time given to it than whether it takes place in the evening. But obviously, there are many other people involved.
Yeah, I mean, we will make time. It won't be shoehorned in anywhere. There will be enough time for this and time programmed for the community hearing. So just from anybody's perspective that's on the call that would be involved, is there an issue with holding it through the day? No, so we could do that. Okay. The other thing that I've omitted, fine for you, brilliant, thank you. The other thing I've omitted here is the bespoke session with community wind power, which again, it could take a day. I don't know with the weight turbulence and everything else to be discussed. So I think we're talking that we're going to look to have to go into the second week, but it will depend on whether or not the aviation issue falls away as being an inquiry session or not. So I'll have to play around with the dates, and what I'll do is I'll ask parties what their availability is the week after. It's not ideal. And it links me on to the next question, which is that my view is that oral sessions could be held virtually. I find it's worked very well for previous wind farm inquiries that I've concluded, particularly where there's only a few witnesses involved in each session. And you can even see today, this has worked quite well, I think, with you all being on screen. So the applicant and CWP have asked for these to be held in person, but is there any compelling reason why that should be the case? Mr. Trinick?
Certainly, sir, since, well, for the last 10 or 12 inquiries, they've been in person and they work much better as a result. The reason they work better as a result is because there are always bandwidth issues that arise during virtual inquiries. It is a lot more tiring to do a virtual inquiry, sitting in front of a screen for 6 hours. Therefore, the working days become shorter. Those are two good reasons, added to which, although I can't speak for local population, actually I think it's a very good thing that we all meet in one place and that local people get to see the applicants' witnesses in person. If they're cross-examining them, it becomes a better process altogether. So I'm strongly in favour of in-person inquiries.
Would that be for all oral processes though, Mr. Trinick?
Yes, it would.
Yeah. Okay. Mr. Fryer, you'd also mentioned in person.
Yeah, I'd agree with everything that Marcus has said. But the virtual meetings are a bit of a hangover from COVID days, to be honest with you. I think they've potentially had the time in certain elements, and therefore in-person meetings are far better.
Okay, Ms. Holmes?
Originally, before I came to this thing, I thought that I would prefer in person, but in actual fact, virtual probably suits some of the witnesses we would want to bring because not all of them live locally.
Okay, I mean, I've had that situation before, and we can accommodate that by bringing someone in, could say roll them in on a laptop, but basically we can have them join virtually into an inquiry, even if it's in person. So that wouldn't be a reason not to hold it in person. Mr. Lesprince.
Well, I like the idea of the community hearing being in person.
Okay. Well, the reason I'm talking about this, obviously we have a guidance note on virtual and in-person oral sessions and the benefits of holding a virtual session, obviously with the travel efficiencies in terms of carbon savings and overnight stays and all that kind of thing for everybody, and accommodating a hall for everyone. However, there is also benefits in meeting in person. There are a lot of people on the screen here, and I'm finding that I can't see everybody. I'm having to go between the two screens, which is less than ideal. I like to see people and see what they're doing. So I'd be in favour of in person, but then we come to talking about a venue. Is there a suggested venue that anybody has, or is there a council building that could be used? Yes, Ms. Gould.
I mean, there are several venues in West Kilbride, and I'm sure Ms. Holmes could suggest some in Fairley. But there are several. I mean, in West Kilbride, there's a village hall, there's a community centre, there is the Barony Centre. These are all places that can be used for meetings.
Okay. Mr. Finlayson, I'm just going to come to the council. I mean, is West Kilbride the most representative place to hold an in-person sessions?
I think so, Mr. Edwards, yes.
Okay, and can the council suggest anywhere, or do you have a building that we could use?
I couldn't suggest one off the top of my head, Mr. Edwards. We'd have to look into that. But the venues that have been mentioned previously would be suitable, as I understand.
Okay. Okay, so I'll put this all in the meeting. Yes, Ms. Holmes.
So the thing about if you had said use Fairley, there is nowhere that you would get good reception, that you could have a hybrid meeting. So are you looking for a venue that is going to be adaptable to having it hybrid and have people come in virtually as well?
Yes, so one of the one thing as well is that in DPA and for many other people, we've moved to electronic working. Certainly it's not impossible to get everything onto a system and work offline, but for our purposes, it would be better to be online, but also so that we can actually live stream the sessions so that everybody can watch them in real time and record them. Mr. Finlayson.
Back to the program. Yeah, apologies there. Just going back to the point I was going to raise earlier before you raised your question about availability. Well, firstly, I confirmed just now that both myself and Mr. Davies would be available in the second week, so I can advise you that at this time. But going back to the programme, could I make a suggestion that the programme's amended very slightly to have the policy hearing session before the landscape and visual impact session? That would appear to be sensible to my interpretation.
Yep, well, I've certainly done that in the past. So, Mr. Trinick, do you have any issues with the policy session happening first?
No, that sounds fine to me.
Right. I realise this is going on a bit in terms of timings, but obviously there'll be travel involved for myself. I'll need to travel to West Kilbride. So if we all agree that we would start on a Monday. Is everybody content with starting on a Monday morning at say 10? Mr. Trinick, would that work for your party?
It would.
It would. Okay. And take it all 5 days, and then we can talk about the week after. And then we can talk about the week after. Okay. Well, when the note goes out, I'll try and set out a timetable and we'll see where we're going in terms of the number of days. I'll likely look at putting aviation right at the end because that's the one that looks like it'll drop off. Okay, so the timelines for submission of documents. If you see Annex B of the agenda, there's a draft timeline for the inquiry process. I'll confirm this timeline in the note of the meeting. Are parties content with the timescales provided for submissions? Mr. Trinick?
They look very doable.
Okay, anybody else? You're happy with that?
I suppose, sir, just for completeness, that's subject to the exchange at the airport and those instructing Mr. Trinick and the applicant we're going to have over the next 7 days about progressing matters. So that obviously came up today and wasn't addressed in your Annex B, but in principle, in respect of the process you allocate for us, the timings would work for Glasgow Airport.
Okay, thank you. Mr. Thompson. Sorry, Mr. Thompson, you're on mute.
Two things. One is, when is the local hearing to be held?
Well, is there a particular day of the week that would suit everybody? I mean, if we're looking at probably Thursday would be the earliest that we could hold the community hearing.
Thursday when?
It would be Thursday, 26th of February.
Okay. And secondly, Marcus was kind enough to offer to send me documents on the environmental impact assessment. I think it would be handy for us to actually have the applicant take us a walkthrough of his site or explaining it on site, so that when we came to the local comment, we were commenting with some degree of certainty, as opposed to there may be errors in our map reading or in the map depiction. And so, rather than have a sort of this is this and this is that, and people, putting comments back and forth, if we've got a certainty as to what we're commenting on, which could be achieved by having a day's meeting on site fairly soon before the weather breaks, it would probably save everybody time in it.
Okay, noted. We're going to come to site inspections in a minute. Now, Miss Gold, and then Miss Holmes, and then Mr. Trinick. Oh, yeah.
Okay. So I was going to ask you something about site inspection, so I wait to come to that. Thank you.
Okay, Miss Holmes.
Just really, I'm assuming that the applicant will have available at the venue that you're going to use all the photo montages and all the documentation that we had on view at the village hall here for the public when they did their consultation. And I would like to if there's a copy, can we have it? Can I request that as soon as possible to have myself? I know it's all online, but it's very helpful to have the paper copies of everything in front of you. Is that possible?
Well, firstly, I'll say that there will be a hard copy. If we're holding an in-person session, there'll be a hard copy in the hall. Generally speaking, that's just for anybody to use, but also if a witness requires a copy of it. It's up to Mr. Trinick and the applicant's team, because there's a heavy cost implication of producing the EIA.
Yeah, how many spare ones there are at the moment. I think we need to know how people are going to appear in the relevant sessions of the inquiry. Because if they are parties, then clearly they need the visual, the hard copy of the visuals, if nothing else. So I think for those who want hard copies, ask us, and we'll get back to you. That's the answer to that one. The other point I was going to make was in relation to what, because when I said your timetable looked fine, I was forgetting aviation. My suggestion is you might want to pull back initial further written submissions to something rather earlier than Christmas Eve, given that we've got a February inquiry, and given that those written submissions may inform you on the need for further oral process. You wouldn't want to wait until early January to discover we've got another inquiry session. So I would suggest that you might want to ask people for further written submissions by mid-November, but allow a further 2 weeks beyond that for aviation.
Yeah, I think this has moved on slightly. The further written submissions timetabling is really for those fairly simple, straightforward questions on further written submissions. Whereas I think now what I'm looking at is almost a statement of case in terms of noise and aviation. So I'll accommodate that, Mr. Trinick. Right. So let's have a look lastly here. Now, the applicant has submitted a foundation document list with hyperlinks to documents that was dated 9th of October this year. It seems to be missing relevant decisions, court judgments, but I'm assuming that's because those will become supporting documents rather than the foundation documents. Is that correct, Mr. Trinick?
That's correct.
Yeah. Okay, so this foundation list is to be used and referred to by all parties participating. The applicant will liaise with parties to update this foundation list with submission of a final foundation list 4 weeks from today's meeting. Further supporting document statements should be submitted by the 26th of January 2026. All supporting documents and statements should be submitted to DPA by email and in a Word format. Once all documents are submitted, the applicant will finalise the full document list prior to the oral sessions. Is everybody content with that approach? Yeah, no dissenting hands, that's fine. Right, other procedural, site inspections. Okay, I wish to undertake unaccompanied site inspections prior to the oral sessions in February. In general, I will visit the representative viewpoints contained in the environmental report and the residential visual amenity assessment. Are there any other locations which parties consider it essential for me to visit? And I can include within the note, I can give parties a week to think about this and come back if necessary. But Ms. Gold?
I think it is essential that you visit the site of the proposed Bess, please. Will you consider doing that?
Yeah, visit the site of the what, sorry?
The proposed Bess, please.
Okay, yeah.
Thank you.
In general terms, what I always do is I go onto the site and walk the application site itself. And then I go to the representative viewpoints where there's likely to be at least a significant, well, identified as a significant effect in the EIA, and those which are in contention, and then any others which I feel would be useful for me to look at. Mr. Thompson. You're on mute. There you go. Perfect.
Now on speak. I would like the site walk because I believe that some of the ground covered is impractical. slopes are quite steep in places, and therefore it may not be as easy to construct as the plan would suggest. Two of the turbines, considerable bridge required at one point to get from the Bess site over to the ground floor.
Okay, thank you. We'll come back to whether we have an accompanied site visit in a second. Mr. Grosvenor.
My query was going to be that very same issue. On all of the inquiries I've been involved with, yes, there's been a unaccompanied site visit, but then there is an opportunity for an accompanied site visit. So, I would suggest that. Wait to hear what Miss Holmes says.
Okay, Miss Holmes.
As usual, I'm just assuming that you'll be visiting Fairley on the coast, and as one of our objections was the fact that we felt we were being besieged by industry on all sides. I assume you'll be looking at what we already have in Fairley and what's proposed for Fairley, etc. I'm meaning the Peelport site and, the industrial site and what we have already.
Yes, that's correct. So I'll look at the settlements in the area as well, and I'll look at the cumulative visual assessment that's been done by the applicant as well. So in terms of an accompanied site visit, what would parties want to do with that? Is that just to visit the site itself? Is there a reason that the site can't be visited separately? Mr. Thompson, you made the point that you wanted the applicant to point out various topographical features. Yes, Mr. Thompson.
Yes, I'm walking the site on the plan that was produced on the 18th of 24. The layout didn't always seem to work, and it was silent as to how they were going to bridge the Cauldron Burn, for instance, which is quite a substantial declivity. It needs more than just filling with pipes, because there's a considerable drop between the hard ground that they require to track on and the course of the burn, which is in quite a deep valley, quite wide. But it was things like that I really wanted to have the advantage of having a site meeting with the applicant, so I was certain comments he was making were reasonable, and it wasn't just that they've made a mistake with some reading terms.
Okay, Mr. Drinick.
So I'm worried about this. The site layout has been devised with a view to construction in mind. We don't put forward schemes that can't be constructed. What I'm now hearing is someone wants to debate the constructability of the site. That's not just a matter of walking around. If Mr. Thompson wants to bring evidence on constructability, it introduces a completely new topic into the inquiry. We're not willing to walk around the site just pointing out features so that someone can say we don't think you can build it. This has been now part of the inquiry process. Either we're going to debate it or we're not. And so far, I haven't heard of any need to have a session on constructability. Okay. I don't think there is a need.
Well, I object to that. I'm an experienced construction person, a professional, and the reason I've asked for this is just to be sure that what I'm saying is correct, rather than go off on a mistake, because it may well be that the plan we're work for, it's a case of large hands and small maps, whereas if your guys are taking me around, I'm then certain that the comments I'm making sense, rather than really. And that was raised in my letter prior to the original document. So it's not a new item. It is one that had already been stated. And Rita Holmes and their friends of the Rio Shield Park have seen the letter and understand what I'm saying.
Mr. Thompson, my suggestion is that you take the plans which have been submitted as being correct, and you write whatever you're going to write based on those plans.
It has already been submitted.
Okay, and what I would say to you is, rather than an accompanied site visit, I think within, I'll give a set period within the note, but if you want to make me aware of particular topographical issues on the site that you'd like me to look at when I do my unaccompanied site visit, you've mentioned the burn, the cavity, the deep valley. If you want to tell me where those are, I can have a look at those myself. And the location of 2 turbines on steep land, I can certainly have a look at that myself. I'm a bit wary about taking a lot of people onto the land from how it's been described. Would that work, Mr. Thompson?
It's a very open site, and people are walking out regularly. There is some problems with the police and forestry extraction, but that's mostly at the western end of the site. There is, if you'd like, I will go when as you're making your site visit, I can meet you on site, point out places I have concerns, and then leave you to make your own judgment.
Yes, well, I think I might ask for that in writing. Well, I will. I'm going to ask for that in writing, so you can tell me where. It wouldn't be appropriate for me to meet just yourself on site, but what I'm going to do, I'll put down a marker that during the sessions, if there's a need for an accompanied site visit, for example, if we're in a noise session and it transpires that we should go to a property, then we can arrange that after the event. So I'll do an unaccompanied series of site inspections prior, and then I'll keep it under review. But there'll be 7 days after this note of the meeting where people can tell me if there's any other particular places they would like me to visit. Okay.
And as I say, Christian is going to send me the documents on his environmental impact in the organisation.
Yes, yeah, they'll be in liaison with you, Mr. Thompson, about whether that's links or hard. You can arrange that between yourselves. 7 days. Okay.
They have to doing it as a commercial risk. We're not necessarily required to underwrite his losses.
Yes. In terms of other procedural matters, parties are encouraged to abide by the timescales for submissions. Unsolicited correspondence and late submissions will only be considered if there's justified and exceptional circumstances to be accepted. Is that noted by everyone? Yeah. Summaries of case and closing submissions will be invited in writing for the oral sessions, with the objecting parties given 14 days after the last session to provide their submissions, and the applicant 14 further days to provide its submissions. Is that agreed? Yeah, I mean, it will depend on the amount of detail we go into. There'll also be a requirement for summaries of case to be provided. Mr. Trinick, have you provided those before?
Yes.
Yeah, so I'll include that within the note, but that would be most helpful to myself and for the Minister. Now, in terms of contact details, should you have any questions, please contact Hazel Bailey at the Directorate. Her details are on the PEM agenda, but will also be included in the note of this meeting. I'll issue a note of this meeting by Friday, the 31st of October, and within 14 days of receiving that note, you must confirm to me, DPA, which, if any, of the hearing or inquiry sessions you intend to participate in. Is that clear to everyone? Yeah, thank you. Now, are there any other relevant matters? No. Yes, Ms. Holmes.
Just really who to contact personally to get the paper copies. There's obviously somebody here at the hearing today. Can I just say today that I would like the copies of the documents that were in our village hall, if they are available, and if they aren't, let me know. Is that appropriate or inappropriate?
Do we have your contact details?
Yes, do you want them right now?
After the meeting, but if you email, sorry, I'm going over your head, Mr. Edwards. If you email the case officer then we'll get your contact details from that. Then we'll be in touch with you.
Okay, thank you.
Brilliant. Mr. Pearson.
Yeah, sorry, this was just a last minute clarification from myself. I kind of missed it in the process. It possibly lies in policy and legislation. One of the issues that I raised in my objection put in on the personal level was to do with the wind capacity study which exists within North Ayrshire Council, which was carried out in 2018, where they stated that the area under study here should not be used for further wind farm development. I note that it didn't come up, in the North Ayrshire Council objection. I don't think it was they concentrated totally on the visual and landscape aspects. But I just wondered, where does a document like that already exists within our local council area lie in terms of this process that we're going through here? It hasn't come up at all in the conversation today.
Sure. I'll invite Mr. Finlayson to come in first, and then I'll comment.
Thank you, Mr. Edwards. Just to confirm that the matters raised by Mr. Pearson were considered by the council are in the submissions made by the council.
Okay, thanks for that.
Thank you. Yeah, so that wind capacity study would have informed the landscape and visual impact assessments and the reasoning by the council. So if that document was to be discussed, it would likely be discussed in the landscape and visual inquiry sessions. If there was a question about its weight to be given to it or the role of that document, that might come up in the policy and legislation session instead. Does that make sense, Mr. Pearson?
Yeah, that's fine. Okay, it was just for clarity. Thank you.
No, thank you. Are there any other relevant matters?